A very good afternoon, ladies and gentlemen. I bring you warm greetings from the very cloudy city of Arusha, Tanzania. My name is Gabriel Achai. I'm speaking to you from the East Africa Law Society, situated at the East Africa Law Society House at PPF in Njiro. This afternoon, we are honored to host you for this very important discussion on cross-border crime. As you all know, we are living in a highly globalized community, and as such, interactions are leading to a number of vices that are emerging out of it in the name of cross-border crime. To mention but a few, you have quite a couple of terrorism cases, money laundering cases that are going on within the community as we speak. This afternoon, we are privileged to honor to host a panel of distinguished ladies who have both gained the experience and knowledge in this field and are here with us to share their insights on cross-border crime in general and within the region. We are streaming this session live for those who are on Facebook, and if you're on YouTube, you can also catch the session live. We'll be running this session for 2 hours, so we'll be stopping at 4 p.m. exactly. This session is going to be moderated by Miss Brenda Imelda Mokoka. She is an advocate of the High Court of Kenya, and she works as a prosecutor in the Office of the Director of Public Prosecutions. She's a member of the East Africa Law Society Young Lawyers Committee and also a member of the East Africa Law Society Criminal Law Committee. Ms. Brenda Imelda, it's an honor to host you, and you can take it on from here. Thank you.
Thank you so much, Gabriel. Thank you, everyone, for joining us this afternoon. So we will just get right into it. Our first speaker, we have Dr. Marcella Odero. Dr. Marcella Odero works also as a prosecutor at the Office of the Director of Public Prosecution. She is also an international criminal and human rights law specialist with over 10 years of research, teaching, policy analysis, and policy and advocacy experience in criminal law and counterterrorism. Ms. Marcella, you can start us off with your presentation. Thank you.
Good afternoon, everyone. My name is Marcella, as you've been told, and I'm also an advocate of the High Court of Kenya. I will be presenting on combating counterterrorism in East Africa, and my presentation is on emerging crimes. It's on cross-border crime in East Africa, emerging crimes in the region, and the strategies partner states can adapt to counter cross-border crime in the region. To begin with, cross-border crime is a crime that maybe starts from one country and is completed on the other region, just for clarification purposes. And this happens a lot, and this is happening a lot in the East African community at the moment. And there has been a rise on specific types of cross-border crimes, especially terrorism, terrorist financing, human trafficking. This is quite a lot, and radicalization. This is something that we have seen arising in the cross-border in between the East African states, and it is something that we hope very soon we'll be able to contain and reduce the numbers. To begin with, on emerging crimes in the region, we have seen so many crimes in the region, but the biggest crimes that are happening in cross-border crimes, one is drug trafficking. We've seen a lot of that. We've also seen a lot of human smuggling and human trafficking is happening a lot in between the countries. And one of the biggest challenges with human smuggling and human trafficking is sometimes individuals do not even know that they're being trafficked. And so it raises an issue when it comes to prosecution, because we do not, for example, if somebody removes you from a rural area to an urban area, or from Tanzania promising you a job, there's a bit of modern slavery and servitude in it. And it becomes difficult when you try to explain to someone this was human smuggling and human trafficking, and they knew they were going for a job, and prosecuting that becomes a challenge, and that is quite in the rise, not only cross-border, but even within the country itself, because moving someone from a village to the city is, to some extent, sometimes to work, and without the appropriate remuneration is exploitation. So that also is something we see a lot. A lot of contraband goods, that's also an emerging crime that we see. And we have a lot of tourism financing, a big problem we face, especially Somalia to Kenya, Kenya to Somalia, or Somalia to the East African region, because we have a lot of hawalas. This is transfer of funds. It's a method terrorists use, for example. For those who do not know hawala is, for example, somebody might be in Europe. It's a more of financial transfer that happens a lot in Somalia, whereby money is transferred from one individual to another individual. For example, I would give Brenda money. We're both in Kenya, and I will give Brenda money. Brenda wants to send money to someone in Somalia. So you see, the transaction was between me and Brenda, and Brenda is the money agent. And then the person who issues the money to the individual in Somalia is does not leave a trace of the money coming from Brenda to the individual in Somalia. So this is quite a big challenge. It's something we're trying to counter. And I hope with time we'll be able to contain it, but it's a very big problem in the East African region. Another big challenge we have is radicalization. There's a lot of radicalization, and now the trends are changing. It used to be Al-Shabaab only in East Africa, but now ISIS is gaining its roots in East Africa. And as soon as, or as later as yesterday, we had a few individuals charged with radicalizing, recruiting terrorists to go and participate in terrorist activities for ISIL in DRC. And as you can see, because terrorism is such a huge crime and menace, it is, you see, it's going past boundaries now. It used to be Kenya, Uganda, Tanzania. Now it's spreading to DRC, Congo, and the likes. And now it's becoming a bigger issue. And another challenge you have in cross-border crime is poaching. There's a lot of poaching between Kenya and Tanzania because of the Masai Mara and the in-routes in between that. A lot of cross-border crimes happens in terms of elephant tusk and all this. Because of the vastness of the Mara, it is easier for poachers to cross in between Kenya and Tanzania, and we're seeing a lot of that. And all these crimes, I'll not go into the laws that cover these crimes because I think Lorraine is going to cover that. But in Kenya, as a country, we are trying so much, and we have different laws to cover different things and to cover and how to handle them. And as I said, terrorist financing remains our biggest challenge in cross-border crimes, because a lot of money comes in between. And with the rise of, again, other than Hawala, M-Pesa, it gives us quite a challenge. And sometimes prosecution may become a challenge between the East African countries, but not so much because you have a bit of cooperation, but yes. And money laundering is also quite huge. And if you look at now with the Bitcoins era, you find that money laundering has gone to such an extent in East Africa, in that now they have machines, they're called money boxes in certain malls. For example, in Kenya, we've seen this whereby if you have Bitcoins, you can go to certain malls in Nairobi to withdraw it. It's something that looks like an ATM machine, and you can go and withdraw cash from these places. And it's growing in East Africa, and this is something that is also emerging and growing quite rapidly. And in money laundering, you get that it's also becoming quite difficult. Without appropriate laws to contain this, it remains a big challenge in the region. And so those are main challenges we encounter in terms of counter cross-border crimes. So I was forgetting one more, and this is cybercrime and cyber attacks. We're having quite a lot of that at the moment, and the more society is advancing, criminals are also advancing. We've seen issues whereby in 2023, if I'm not wrong, the US military base in Manda, 2022, a while back, was attacked using drones. And you can see this came from terrorists came from Somalia all the way to Mombasa and Manda, the coastal region, and attacked a military base. So cross-border crime is on the rise, and this is something we need to have a look at in a wider scope, and something we need to find ways as a region to cooperate and work on to be able to contain it before it gets quite out of hand. And then on the second bit, I'm supposed to look at the strategies partner states can adapt. In Kenya, for example, we have various strategies, but the biggest strategy that is working for us, which I think we need to work on as the East African community, is interagency partnerships. Because in Kenya, for example, after 1 or 2 terrorist attacks, we came back with an interagency partnership network whereby the prosecution works with the Kenya police, works with the different agencies, asset recovery, the different government agencies. We work together to be able to counter crime, and especially these organized and emerging crimes that are on the rise. And I believe this is something the East African community we really need to work on, because if we have mutual cooperation between states, between one another, it would be easier to contain and manage some of these crimes that are emerging and recurring, and how we can manage them. Because in Kenya now we have prosecutorial-led investigations. These are investigations, for example, whereby if there's a terror attack and police are there, prosecutors are also called on site to come and have a look and help investigators on how to solidify and make solid cases, or rather how to handle the matter. And this helps a lot, especially in transnational, this helps a lot in these major offenses like terrorism, money laundering, and all this. Because when you work as a team and when prosecutors lead the investigations, it helps in terms of having successful prosecutions, which is the end goal anyway, for it to act as a deterrence. Another strategy that has been adapted and will work better, which is working in the East African community, is while we have enhanced border security, we are now having things like one-stop border post, which is a bit of a cooperation. This helps in terms of the porousness of our borders, and we're having streamlined procedures in the borders. And this is a good thing in terms of when we have streamlined procedures, that everything works. And this is in line with the East African Community Passport as well. We're able to, when we have uniformity, it helps in terms of managing crimes and illegalities that will happen in the borders. Another strategy we have, which probably the East African community can adapt, is capacity building. Capacity building in the sense that before you would find that, for example, if you look at the Kenya police, we have the Kenya police who are trained with investigations. And then we have the General Service Unit, who conduct a different type of activity, quell riots and things like that. Previously, there was no specified training for cross-border crimes, and there was no coordination between the agencies. Like I said before, now we have interagency cooperation. The second thing is now you'll find that at the borders, for example, because of their porousness and because there's different police officers manning different border spots, you find that at every border post, there's a trained police officer to handle certain crimes across the borders. This is terrorism, this is human trafficking. And with this capacity building, if the whole of East Africa would embrace such a thing, we will have made steps, and that would be a strategy to combat cross-border crimes as well. Another thing we have is in Kenya, for example, you have Article Section 14 of the Section 18 of the ODPP Act gives us asset recovery, which is a deterrent. It's a strategy we are using in the sense that the ODPP can recover assets that are acquired through cross-border crimes. For example, or terrorist financing, if a crime started in Kenya and the funds were transferred to Kenya, money laundering, or all these things, once we prosecute this individual and they're charged and they're found guilty, we have an asset recovery strategy. We recover all the assets and don't let them back to the accused persons. And this way, this also acts as a deterrent, because now it means that we're trying to deter people or other members of the community and tell them that if this happens, again, like I said, your funds will go, and it's a strategy to combat counterterrorism and cross-border crimes as well. We also have public awareness, participation, and education. You find that in most cases, we have capacity built the community that in places where, because if you look at how cross-border crimes work, if it's physical crimes like contraband or terrorism, people leaving one state to the other, they do not use the main migratory routes, they use alternative routes. But members of the public have been educated, informed, and told on what to watch out for. And sometimes they're the ones who call the police officers, they report to the ODPP hotline, whistleblowers, they act as whistleblowers and inform the public, this is what is happening. And we have had successful convictions from information from members of the public. Another strategy we have had is advancing technology. What is happening now is that the borders are manned by drones, because sometimes things happen quite far away from where police officers or security agencies are. So we're using advanced technology to monitor the borders, to monitor activities, and that way we're able to see what is coming or know what we might be hit or not hit with, and prevent it before it becomes a disaster. The other thing, a strategy we are using again in combating this is we have a reintegration process whereby now, if we find persons participating in this, because in Kenya we have the alternative justice system, we are reintegrating these members of the society, and some of them are even recruited to help police officers and investigative agencies in countering crime, in countering these emerging crimes in the society, and this has helped a lot. We also have the disarmament and demobilization, whereby the East African community, this is something the East African community has done, and we have to applaud them for, is because before there was a lot of light arms passing in between the borders, and what they have done now is the East African community has implemented laws whereby all small and light weapons have to be registered, those that belong to the police, those that belong to the military. And this way, because most of them are registered, unless you're a licensed firearm holder, you're put a task to explain where you get your weapons from, and this has been quite helpful in terms of trying to minimize the passing of light weapons across our borders. We have an organized crime court in Kenya. This is in Kahawa, whereby I'm not sure if Tanzania or the rest of the East African community have it, but in Kenya we have Kahawa Law Courts. Kahawa Law Courts is the organized crime court whereby cross-border crimes, counter-trafficking, terrorism, human smuggling, all these people will be charged specifically at Kahawa Law Courts. And the reason we did this is we have specialized prosecutors who handle this specific matter at these courts. And this strategy is working now, because previously you'd find that if someone was prosecuted for a crime for terrorism, it would take years and years before the matter was concluded. But with the specified courts, because the workload is a bit reduced and is specific to specific crimes, both the judges and the prosecutors and investigators are all capacity built. And this is something that is working quite well with us in terms of terrorism. And I believe this has reduced a bit the terrorism numbers of recruitment terrorist activities in Kenya, because everybody knows now if you commit a terror attack, you're going to Kahawa, and Kahawa Court is feared, is the word. So yeah, that has really helped in terms of a strategy to counter cross-border crimes and emerging crimes as well. And that is basically how we are handling it at the ODPP in Kenya in terms of cross-border crimes. And yeah, we have a lot of trainings. There's a lot of capacity building with both civil society and the government itself in terms of training people on how to handle and how to prosecute cross-border international crimes. And this has helped quite a lot. Yeah, thank you.
Thank you so much, Dr. Marcella, for that. I think we have one question from Harub Suleiman, who's asking, considering the intricate web of factors contributing to cross-border crime in East Africa, including socio-economic disparities, political instability, and porous borders, how do we envision leveraging technology and data sharing mechanisms to enhance our collective ability to identify, track, and disrupt illicit activities across the borders while safeguarding civil liberties and private rights? Maybe you can answer that.
Thank you very much, Mr. Harub Suleiman. First of all, I will go first of all with the human rights approach to this. In Kenya, for example, now we use a human rights-based approach in all our investigations. This is, for example, we will not, even if you're arrested today, you will be informed you've been arrested, or when investigations are happening, it will not go without a warrant, especially in terrorism, in all these cross-border emerging crimes. It will not go without a warrant, and that is one thing we do. Another thing is you have the Office of the Data Center. We have everything first goes with a warrant, and the second thing is we have a problem when it comes to data sharing mechanisms, because issues of sovereignty come into place, issues of liberties and how this data has been obtained, because the prosecution service in Kenya, we've been hit not once or twice by the courts, whereby we've been told we violated the human rights of the individuals without getting warrants, without following due process. And because of this, on our end, we ensure that we follow a human rights-based approach in our prosecutorial matter. But the socioeconomic disparities and porous borders, like I said at the beginning of my presentation, we're trying to do, there's a collective East African, the East African, what is it called? The East African Protocol on Security allows for data sharing between the East African countries. And we are trying, the East African communities are trying to have modalities whereby we work together in terms of identifying, tracking, and disrupting using the 4Ps. The 4Ps, which are participate, prevent, protect, and prosecute. And we are hoping that once we're working on an East African counterterrorism document, still in its initial stages, and once we set this in force, we're hoping that we'll be able to we're leveraging technology. For example, in Kenya, it's quite advanced because the Office of the Data, we have the Data Protection Office, and we have, and the Communications Authority are on toes in terms of looking at the attacks and everything that goes on. But the international community has been quite helpful in terms of, for example, when we suspect technology is being used in a bad way, we will approach Facebook, we will approach YouTube and tell them, please pull this down, please do this, to prevent the spreading of terrorism and all this radicalization material and things like those. So we always ensure a human rights approach is applied, not to trample on the civil liberties of individuals. I hope this answers your question. And we work with the international private companies to help us with this as well. Thank you.
Thank you. We also have Rachel Itende-Rezwe. I hope I'm spelling it right. I'm so sorry. Regarding the issue of poaching, how is it generally affecting all EAC countries? And she's also asking if there are any materials about this issue.
Poaching affects the East African community. One, it affects our economy in terms of illicit funds coming in and out, and because you'll find that most of the poached, the elephant tusks and all this come into are mainly shipped out of the country, and this creates a lot of illicit funds into the country, and also our security, because threatens the security of the human beings, the individuals working in this, for example, Kenya, KWS, and the Tanzanian version of that. And not only do they affect the community, these funds sometimes end up being what is used again for what? Terrorist financing, which is a threat to the national security of each and every country affected by this. And yes, we have materials on this, and if you don't mind, if you leave your emails, I'll share it with Brenda, and Brenda can share it with the rest of the colleagues maybe later. So yeah, thank you.
Yes, this is fine. Maybe now we can move on. The other questions can be answered during the Q&A session. I can see Mike Bin Mwanda is saying, Professor Mwanda from DRC Congo is thanking all of us. Esther Mugai says, thank you, Dr. Wadero, for a very enlightening presentation. Also, Advocate Bona Bolmadut from Juba, South Sudan is also saying the presentation is very educative. Thank you all for tuning in. Next, we have Lorraine Ochiel. Mr. Ochiel is an advocate of the High Court of Kenya, and she is the current program lead Transnational Organized Crimes in East Africa. She works for the International Development Law Organization. She has a keen interest in the rule of law, access to justice to work, fueled by her growing skills and experiences working on related programs, including access to justice, commercial justice sector reforms, criminal justice reforms, and most recently, transnational organized crime. Thank you so much, Ms. Lorraine. You can proceed with your presentation. You can kindly unmute. You're muted.
Sorry.
It's okay.
Thanks again. Thank you, Brenda, for moderating the session.
You're welcome.
Thanks again, Dr. Marcella, for your preceding presentation as well, which was quite related to the presentation and prepared for us. I will try and take just about 25 minutes at max to run through the presentation I prepared, and then we can have some dialogue, hopefully, around the issues. I was asked to speak on the policy and legal frameworks for transnational organized crime and the challenges that are faced in combating these kinds of crimes, specifically in East Africa. Now, before I get into the legal frameworks themselves, I do find it necessary to first just detail what the definition of transnational organized crime is. And this is specifically because there's a lot of confusion in the definitions between in-country criminal activities and transnational organized crime, as well as international crime. And that confusion of definition usually plays into the ability of TOC, as we call it, actors, being able to identify transnational organized crime and then investigate and prosecute them as such. So from the onset, we traditionally adopt the definition of transnational organized crime provided in the UN Convention Against Transnational Organized Crime, UNTOC, which has 4 key components of what forms or what makes TOC. One is, of course, a crime committed in more than one state. Second is if the crime is committed in one state, but a very substantive part of its preparation, its planning, direction, and control takes place in another state. It is also crimes committed in one state, but involves organized criminal groups that engage in criminal activities in more than one state. So there's a multi-state approach to that. And then it's also crimes committed in one state, but there's the effect of that crime is substantially felt in a different state. So by definition, then we can see that the distinguishing factor between transnational organized crime from other domestic criminal activities is really the transnational cross-country nature of the crime, especially in the way that the crime is planned, the way it's executed, the way it's controlled, the way it's financed, and in some cases, it also includes the way the proceeds of that crime are accessed and used in different countries. With that definition, there are very key characteristics or criminal networks that facilitate TUC, or criminal organizations if you prefer. And we find that understanding of these characteristics is a material component of preparation for investigation and effective investigation and prosecution of these crimes. So first, we find that these crimes, these organizations are usually very complex. They're very corporate-like, and they're very structured. So think a very structured corporate leadership type approach. They have hierarchies in their leadership. They have defined leadership roles, and they also have defined roles for their different members that they station in different countries throughout their network, as well as a very coordinated approach to their work. You'll also find that these networks are very sophisticated, especially in the advent of technology and tech advances. They have access to the latest technology, the latest innovations as far as communication goes, as far as transfer of funds. And a big example given here is cryptocurrency as a way to transfer funds. They have access to technologies for concealing, their activities, as well as the merchandise in transit in the process of trafficking. So based off of this sophistication, then it presents a very complex network that investigators and prosecutors and adjudicators have to consider when combating, planning strategies to combat TUC. They're also structured as very sustainable networks. And so they outlive the different contexts, the different leadership in country. They outlive governments. They even outlive the existence of their individual members, so that the prosecution of an individual member of a criminal organized group is in itself not sufficient to dismantle the group itself. An approach for dealing with the networks then forces us to think through how to dismantle the network entirely without targeting individuals or plus targeting individuals. These networks also thrive on secrecy. So they're very big on oaths and oath-taking. They're big on confidentiality agreements for their members, and you'd find that they have very stringent punishment for members who go against the oaths of secrecy that they have been sworn to. And an example I can give is we've seen cases where in court, accused persons of any different forms of TUC would plead guilty to charges just so that they avoid giving more information of the criminal activities they're involved in. Some of them would be happy to serve jail terms because of the consequence of divulging information relating to that network. And then the last thing about them is they're also very informed, and this is a key component of my presentation, because from where we sit, we can only address or combat TUC if there's full appreciation of how organized these criminal networks are and how informed and researched they are. These criminal networks actually have very, elaborate legal teams that advise them. They do their research. They map out domestic legal frameworks in the countries of their operations. So they already know by the time they're setting up in a country, in Kenya, for example, they already know what the laws of Kenya provide. They know what offenses Kenya has criminalized, what TUC offenses are. They also know the punitive measures that Kenya has provided for different offenses, so that when they set up their networks, they already have plans to counter the different loopholes or the different scenarios that they're likely to encounter in the process of their networks. So you can see by design then that we're dealing with networks and organizations that require similar or even more sophisticated approaches to combating the kind of offenses that they commit. Now, when I go into legal frameworks for TUC, of course, we have frameworks at different levels. We have the international conventions and treaties that govern TUC. We also have some regional frameworks as well. And then within the different EAC countries, each country has legislated on different forms of TUC. But I'll belabor a lot more the international frameworks and the role they play, because they have a key role in the coordination of country efforts to combat TUC. East African countries are already members of the United Nations, and majority of them have are signatories already to international instruments around this area, and therefore by design already countries have registered, by ratifying these instruments, registered a commitment to, or political will for the country to take a global approach or global response to TUC. The parent legal framework at the international level for TUC is the UN Convention Against Transnational Organized Crime, UNTOC as we call it. UNTOC promotes international cooperation for the prevention and combating TUC more effectively, and also provides for the growth of links between TUC and its predicate offenses and offenses such as terrorism and corruption. So it has a very broad, outlook on TUC. It provides frameworks, for example, for the prevention, investigation, prosecution of offenses defined in the convention, but also identifies specific offenses that it requires state parties to look into and to provide sanctions for in country. It is very heavy also on international cooperation. I already mentioned, makes very specific provisions for how cooperation should be approached by the different countries that have ratified it. Alongside the convention comes the 3 protocols there too. There is a protocol to prevent, suppress, and punish trafficking in persons. There's a protocol against smuggling of migrants, either by land, sea, or air. And there's the protocol against illicit manufacturing and trafficking of firearms. So these form the block of the parent transnational organized crime international framework. In terms of function, the convention has identified 4 key types of TUC. There's participation in organized criminal group in its Article 5. It has singled out laundering of proceeds of crime in Article 6, corruption in Article 8, and obstruction of justice in its Article 23. And then the 3 protocols have also singled out trafficking in persons, smuggling of migrants, and trafficking of arms as TUC, as forms of TUC. But of course, this list is not exhaustive. National legislation in most of the EAC countries have provided additional forms of TUC that they legislate and look into. I did mention that for the UNTOC, it's very big on providing frameworks for different levels of combating TUC. So if you look at investigation and prosecution, for example, the convention requires state parties to consider getting into bilateral and multilateral agreements for the investigation, prosecution, and judicial proceedings of TUC, as well as establishing joint investigative bodies that would facilitate these processes across countries. The convention also encourages state parties in this regard to allow for appropriate use of controlled delivery, special investigative techniques by the different competent authorities in country, as well as explore different forms of collaboration, whether or not there exists bilateral or multilateral agreements between countries. It sets out substantive provisions for extradition, for example, including extradition, including the conditions to be looked into by domestic legal frameworks to facilitate extradition agreements, requires state parties to facilitate these agreements once they enter into them in ways that facilitates prosecution. So it doesn't only stop at encouraging countries to get into agreements, but it's also big on encouraging countries to facilitate the implementation of those agreements, expediting processing of requests, for example, and ensuring that requesting countries, the domestic laws of requesting countries are respected in the process. In terms of adjudication, the convention speaks a bit also to jurisdiction, and it requires state parties to take all the measures possible to establish jurisdictions of offenses of the convention. And here it refers to offenses committed in the territory of that state party or offenses on committed on a vessel that's flying the flag of that state party, or an aircraft that is registered to a particular state party. Also encourages state parties to establish jurisdiction of offenses committed by their own nationals or by a national, stateless persons who have their habitual residence in those territories. So by design, then you can see that there is already such comprehensive provisions in the convention itself that East African countries or EAC member countries can explore in designing strategies to better respond to TOC. I want to highlight the last component of the convention that's quite material to response as well. And this is the position of the convention on mutual legal assistance. The convention puts obligations on state parties to facilitate MLAs, to afford one another, the opportunity to get into these agreements, but also reciprocity and extend similar assistance to one another where a requesting party, for example, has reason or grounds to believe that the particular offenses or the victims, the witnesses, the proceeds, instrumentalities, or evidence of such offenses are in the custody of another country. It encourages countries to consider getting into, again, multilateral agreements or bilaterals that would facilitate these processes, but also execution of MLA requests that have entered into, and designation of central authorities by countries that would oversee the execution of MLAs entered into. Encourages countries to initiate, develop, improve specific training programs for law enforcement agencies that have the mandate in law to prevent, detect, control offenses of this nature, and also the mandate to implement agreements that they've entered into. So you can see then that the convention has very specific obligations on state parties, and the state parties, you would see by design that a lot of state parties would then legislate nationally to align, sort of design national legislation that is aligned to the convention as a way to begin to implement or to satisfy the obligations created for them under the convention. It obligates state parties to develop and evaluate their national projects, and also to promote best practices across countries to prevent TOC, to take legislative administrative measures that would ensure implementation of these obligations, among which include, of course, the design of national laws, regulations, national policies, and the whole shebang, as well as encouraging member states to promote, protection of victims of transnational organized crime. This would include victims, witnesses, whistleblowers, and individuals that are one way or another involved in these cases. And this is also a material component of the convention because it sets the framework upon which countries can now set up in-country institutions, protection institutions like witness protection agencies that would facilitate satisfaction of that obligation. Away from the UNTOC, there is also the United Nations Convention Against Corruption, UNCAC. Now, corruption is defined in UNTOC as a form of TOC, so UNCAC therefore becomes quite useful in interpreting corruption as an offense, but also providing frameworks that countries can use or rely on in looking into acts of corruption. It is actually the only legally binding universal anti-corruption instrument, very comprehensive, provides very comprehensive criminal provisions that cover a wide range of acts of corruption, including bribery of public officials, extortion, and that whole shebang, but also offers a platform for member countries to harmonize their national laws on corruption and ensure there's minimum levels of deterrence, through specific provisions of law against corruption-related cases. Under this convention, state parties are also obligated to establish specific criminal offenses that are useful for fighting corruption, especially offenses that may not already be in domestic law. And so this becomes a foundation for a country that's probably limited by constitutional impediments or the history of the country. This becomes their foundation to deal with corruption without having to, alter or interfere with that context in which they work. Then there are several other conventions and treaties, and I will not go into detail into each one of them in detail, but I'll just mention them so we know they exist. And even this list I have is not exhaustive. There's the UN Convention Against Illicit Trafficking in Narcotic Drugs and Psychotropic Substances. Again, this one sets the foundation to ensure adequate supply of narcotics for medical and science purposes, but while also preventing the diversion of these drugs into illicit markets, which would then subject these drugs to abuse or to trafficking. We have the Convention on International Trade in Endangered Species of Wild Flora and Fauna. CITES is what we call it. It's a mouthful. And this one is widely known for regulating international trade of endangered species, as well as including marine species and ensuring conservation and the whole ecosystem there. The UN Convention on the Law of the Sea is another famous one, sets out framework for conservation and management of marine resources, and also prevention of overfishing and protection, rather promoting sustainable use of oceans. The last three I'd highlight is the Stockholm Convention on Persistent Organic Pollution. This one's role is really to set the framework for elimination or restriction of production and use of persistent organic pollutants, some of which can actually impact aquatic ecosystems. And then the Budapest Convention, cybercrime, promotes cooperation among countries to investigate and prosecute cybercrime, but it also defines cybercrime and identifies, online fraud, child pornography, security breaches, as well as strengthening cybersecurity in countries that have ratified it. Lastly is the Arms Trade Treaty, which provides broad provisions for conventional arms, and it's sort of an expansion of what is provided in the protocol that I talked about, the protocol to UNTOC. So here it details the different categories of conventional arms and how countries should approach regulation of those. So this is at the international level. At the regional level, unfortunately, there isn't as much policy legal frameworks at regional level that address TOC specifically, but there are some efforts by regional outfits such as the East Africa Community and the African Union to try and set up protocols and strategies that countries can use or rely on. So a good example here is the AU Convention on Cybercrime and Personal Data. And this is the only regional framework actually that looks at cybersecurity, cybercrime and personal data protection, provides guidelines for African states for prevention, investigation, and repression of cybercrimes. But the convention itself does not isolate cybercrime as a form of TOC. It just provides for cybercrimes as a standalone issue and then prescribes how countries can approach it. And then closer home, of course, is the East Africa Community Instruments, and there are numerous efforts there at the East African Community that EAC member states are implementing but can also take advantage of. There is EAC protocol and regional strategy on peace and security. There's a protocol on combating illicit drug trafficking, EAC transboundary security framework. Most recently, I think, is a strategy for piracy and maritime security, as well as the ongoing development of the EAC refugee policy. So you can see then that there is a lot of movement in terms of policy and legal frameworks at the regional level, EAC level especially. The question always remains, how much do we know about the existence of these and how much do we use them as member countries? At the national level, which is where I'll spend the least amount of time, all of the EAC countries, none of these countries has a particular standalone, legislation per se or policy on TOC. What countries have are specific laws and policies that speaks to individual forms of TOC. And these are largely driven, for example, by the demand for the country to take a position on the issue or the prevalence of the issue in country, or the obligations of that country created by international instruments that I already mentioned. So you'll find, for example, that Tanzania's National Anti-Trafficking in Persons Action Plan, which exists and is a good example, was driven by the demand for Tanzania to take a position on trafficking in persons. The Nairobi Protocol on Small Arms and Light Weapons, again, was driven by the demand for the country to take a position on trafficking of arms. So that's kind of the foundation upon which national legislation is made. But I also did mention that international conventions and regional ones also really influence the type or the choice of domestic legislation that countries put in place because of the obligations that have been created under those instruments. So here, if you look at the different forms of TOCs in the EAC countries, Kenya, for example, has heavily legislated on 5 most prevalent forms of TOC in country. This include human trafficking and smuggling, money laundering, illicit financial flows, trafficking in small arms and light weapons, trafficking in drugs and narcotics. So that's Kenya. Then if you go to Tanzania, because poaching and wildlife trafficking is a big issue there, Tanzania has heavily legislated on those areas. And by heavily legislated, I mean establishment of strategies, of national legislation, of policies, as well as establishment of state institutions that then oversee the implementation of these forms of, or rather, that oversee strategies to combat a different form of TOC. Uganda, because of its very long history with armed conflict, has also legislated largely around human trafficking, especially for forced labor and sexual exploitation, drug trafficking, and trafficking in minerals, because for Uganda, these are the outstanding transnational organized crime issues. I will not detail the full list of legislation for each country. I attempted to put them together, and I'm happy to share this presentation for anyone that wants access to that list to look into them further. Now, when we go beyond legal frameworks, there are also national operational frameworks and mechanisms that EAC member states explore in their response to transnational organized crime, and I'll highlight 4 main ones. One is naturally the establishment of state institutions, which have a statutory mandate either to identify, investigate, prosecute, and adjudicate TOC. An example, of course, is Tanzania. Actually, all of the EAC countries have established police, either police force or police service. There's Directorate of Criminal Investigations, National Police Prosecution Services, judiciaries. And in the case of Uganda, rather in Tanzania, there's the Drug Control and Enforcement Authority. Tanzania, again, has the Prevention and Combating of Corruption Bureau. So you'll find that EAC countries have set up these institutions, again, based off of existing domestic legislation in that area and the different forms of TOC that the country is facing, so that the institutions can focus, of course. The second operational framework has been the establishment of research facilities. And Dr. Marcella spoke to the importance of research in her presentation. So these research facilities, of course, help countries with the collection, exchange, analysis of information, and trends of TOC, because this is then what informs the national positions and strategies within those territories, as well as the policies that countries set up. And a good example is Kenya's National Crime Research Center, for example. The setting up of these research facilities also does help countries focus and prioritize data in this area, which is one of the highlighted challenges in dealing with TOC, the fact that there's always conflicting data in country and across countries, and that makes it quite difficult to have a regional position. If Kenya, for example, has different data from Tanzania on the same issue, and there's no convergence of thought, then it becomes difficult to have regional positions or national positions. The other strategies are establishment and resourcing, especially, of protection agency, which are very material component of effective prosecution of TOC. So protection of witnesses, victims, whistleblowers, all of that is a priority if prosecutors and investigators are to make strides in investigating and prosecuting. And an example I mentioned is Kenya's Witness Protection Program, which is founded on exactly this, this thinking. And then lastly is the establishment of cross-border collaborative frameworks. I've already belabored mutual legal assistance agreements, formal, informal information sharing, extradition, exchange of prisoners. All these agreements are operational frameworks that facilitate response to TOC, and the setup of units, divisions, departments that are specialized in dealing with TOC has been flagged as one of the best practices in the region, because all the countries in the region have set up specialized units. An example, is Tanzania's Asset Forfeiture Transnational and Specialized Crime Division of the National Prosecution Service, as well as Kenya's, Transnational Organized Crime Unit at the DCI. So these then, the setup of these kinds of institutions put spotlight on TOC as an issue, and then prioritize, makes this issue a priority for countries to look into. I'll move slightly away and take another 10 minutes if I have it. Moderator, please let me know. To look at the, what was this? I want to look at the challenges that the East Africa, the EAC member states face in coordinating cross-border efforts. We've looked at ways in which those efforts can be facilitated, but not without challenges. And these challenges for most countries are recurring challenges that then, if they go without proper investment, then we lose the cross-country efforts that have been put in place in legislation and the setup of institutions. Top of this challenge has always been political will to collaborate. And I know that's always a sensitive one, because we never quite know what solutions to propose when you're dealing with political will. But collaborative agreements are actually signed by governments, and therefore without political will to implement them, they remain just that, collaborative frameworks. And that has always been a challenge. It's not a cross-cutting challenge, but it's a case-to-case challenge. And the examples given for when that's been a hindrance to combating TOC. The other challenge has been varying strategic investigative capabilities, and Dr. Odero also spoke about capacities. The truth is, the EAC countries are not all at the same level in terms of capacity. Some countries are more advanced than others. Some countries have more intelligence gathering mechanisms, access to technology, equipment, and tools. And as long as countries remain at different levels of capacities, that does affect the level of collaboration that can be there. Lengthy and technical processes for securing and granting mutual legal assistance has been an issue, because it affects the timeliness of feedback that countries receive. And as we know, some of these cases are purely based on how quickly a country can access information, especially if the plan, if a country has been planning an operation to arrest a suspect, that process is time bound and does not have the luxury of so much time to wait for the other country to collaborate or to translate MLAs and respond to them. Language barrier, again, has been highlighted as a big challenge. Last year, we had a national dialogue on MLAs, and I remember Tanzania raising very specific issues around language barrier. So the context of this example was such that MLAs for Tanzania are written in Swahili. So assuming that the request is sent to Kenya, and the competent authorities in Kenya first have to translate these requests into English, provide a response in English, and then translate the response into Swahili, for example, to send it back to Tanzania. So if you look at the time lost in the language barriers as well, that's been a hindrance, one which I'm not sure I have solutions for. The inconsistencies in systems, legal systems as well, and systems in country has been another challenge. Different countries adopt different strategies for intelligence gathering, data management, reporting, and all of that. And as long as these are not harmonized, it becomes quite difficult to share information, especially because they come in different formats for each country. So that's what I want to put forth for challenges. I was also asked to look at the hindrances that legal systems or jurisdictional boundaries present in the process of cooperation. And what came to my mind in this question was first just looking at the difficulties in balancing national sovereignty and global, interdependence. Each country has its own domestic laws, and these are tailored to the culture, cultural, political, historical context of that country. So it becomes quite difficult to align or to harmonize these national laws to address transnational issues or to shape the global landscape for TOC. But a solution that has been explored for this a lot has been, of course, reliance on the regional and global treaties that I spoke about earlier as a foundation for collaboration in cases where domestic legal frameworks conflict or where they are not facilitative or supportive of collaborative processes. The other challenge with legal systems has been the limitations of enforcing national laws globally. Again, jurisdictional boundaries are rarely clear-cut. And so that lack of clarity with which national laws can apply to multiple countries, or national laws on TOC can be applied to address TOC cases in different countries, becomes an issue. It's still an ongoing conversation. I know there's been a lot of calls for harmonization of laws in the EAC countries, for example, a situation I'm not sure we have capacity to explore fully. And so that remains a limitation. And again, regional international treaties have been a fallback here, including EAC's setup of its protocols and strategies is actually a way to cure these limitations in national laws and to provide members a regional framework upon which to operate. The differences in enforcement mechanisms as well impedes implementation of national laws globally, because if one country has a different set of enforcement mechanisms, a different set of punitive measures, some cases I've seen where one country has criminalized one form of TOC, another country has not, or one country has maximum sentence is another country's minimum. So those kinds of differences make it difficult to collaborate in this area, especially where the punitive measures are less stringent. So you find that countries struggle with how to collaborate in those contexts. And the organized criminal groups I spoke about earlier actually take advantage of those inconsistencies or those gaps in law, and they would map out which country has less stringent measures, and that's where they set up their operations because they're least likely to suffer consequences of that. Now, in terms of, and this is my last two slides, please stay with me. In terms of mechanisms for information sharing or intelligence sharing, there are plenty of mechanisms that have been explored here as well. I have belabored bilateral and multilateral agreements, which is one of the biggest mechanisms. And that covers a broad range of areas, including joint operations, intelligence sharing, information sharing, surveillance, use of control delivery as a strategy, as well as other strategies, informal strategies that investigating agencies use. So these have always been the foundational mechanism for intelligence sharing. But there's also opportunities for example, establishment of fusion centers between law enforcement agencies where they can share resources and expertise and information for detecting and responding to this criminal activity. And this is actually a very good way to integrate the information that's held by different agencies so that you don't have that conflict of data I spoke about or miscommunication between agencies. Collaborative law enforcement has also been highlighted as a mechanism. And this is, for example, what's happening now in the region is there's a lot of multi-agency task forces that have different mandates, but they address similar forms of TOC. And when these agencies work together or dialogue consistently on these issues, they facilitate sharing of information among themselves and then facilitate collaboration. And an example I can give there is the National Anti-Poaching Task Force for Tanzania, for example, or the Task Force on Human Trafficking in Kenya. Through these task forces and their collaborative approaches, a lot of policy decisions have emerged and have been adopted by governments. So that already establishes their value. There is potential, if it's not already happening, to participate in the East Africa community outfits, such as the East Africa Association of Prosecutors, which already brings together representation from the region. And so it provides a very good platform to explore strategies for collaboration and dispel, the strategies that don't work, all of that. There is the East Africa Police Chiefs Cooperation Organization, which actually fosters cooperation between the EAC member states, the police forces, and a big outcome from this platform that I came by was the harmonization of police rankings and establishment of police liaison office within the EAC structure. That's an output of collaboration under EAPCO, which is a platform that countries can explore. And then lastly, platforms, data, what do I call them? Global communication systems or criminal databases, such as, participation in Interpol, which are already structured, it gives countries abroad access to platforms that they can use to gather information relating to cases they're investigating, but also facilitates multilateral interactions between countries. Interpol being an example, but of course there are others across the region. And I believe if not all, majority of the EAC countries are already collaborating with Interpol and have national, Interpol national central bureaus already set up in country to facilitate such cooperation. So I only highlight it as a potential to expand. Lastly, I was asked to look at the resources that are necessary for better TOC response. And I think these are quite generic across institutions and countries. National budget has always been the number one resource. And the tricky part about budget is for a country to have sufficient or at least substantive budget for transnational organized crime, it first needs to appreciate transnational organized crime as an issue. So prioritization of it becomes the preceding issue to national budget. In the cases of Kenya, for example, this prioritization is reflected in the national policies that the country adopts and the positions that the country takes. So national budget and collective bargaining for prioritization of TOC then becomes a responsibility of all the agencies that require this budget to operate optimally. Structured and continuous capacity development is a necessary thing. And I know, Dr. Odero, you spoke already about ongoing existing capacity development initiatives across countries. The truth is, there is training happening and it's coordinated at different levels. The challenge with the approaches to training or capacity development has largely been that majority of it is not anchored on a needs assessment for the transnational organized crime actors, so that there is a lot of generic training happening on TOC broadly, for example, but it doesn't really look at the practicalities of investigating TOC, for example, investigating techniques, emerging technologies, and the complexities of criminal networks. So the kind of training that I propose here as a resource is one that's a lot less theoretical, a lot more practical to the needs of investigators and prosecutors, but also that takes into account those needs as identified by the actor, not assumed by international organizations or any other institutions that support training. So one of the things, for example, that we've been advocating for is the design or redesign of training material, training curricula of the different law enforcement training institutions, and integration of such training curricula in the broader training for law enforcement, so that it becomes mandatory, for example, for police officers, DCI officials, prosecutors, judicial officers. This training becomes mandatory, but also very focused on the needs, that looks at typologies of TOC, the scope, the way TOC manifests, emerging trends, global best practices, all these things that they require to match the sophistication of criminal networks that I spoke about. The last three things as resources I highlighted was research, and I've belabored it. The fact that we cannot design strategies to deal with TUC without data. And here we are not just talking data, we are talking consistency of data, because there are a lot of cases where national agencies that each have a mandate with TUC would have data, yes, but the data doesn't speak to each other. So you'll have, for example, and this is just an example, the DCI in Kenya, the National Police Service, and the EACC, the Anti-Corruption Commission, all have an investigative mandate, but the data that they're running with is not centralized and it's not consistent, and that affects decision-making. So there's need to invest in data as a resource so that it's updated, it's credible, it's relevant, and it's also able to sustain. Then lastly, an update of the technologies, equipment, tools that we use, and that's a big part of capacity and a big part of resources. Dr. Odero, you did speak to, or rather, there was a question earlier in the previous session where the question asked, how are we leveraging technology? The truth is we are struggling as EAC countries in the technology space. There is a lot of effort, for sure, it must be acknowledged, in terms of how investigating agencies have assimilated or adapted to emerging technologies. But we still have to resource these institutions with the right technologies, the right systems, the right tools and equipment to be able to deliver on their mandates. It's one thing to train DCI officials or to train police fast responders. It's another to give them the equipment they need, for example, for border patrol, airport patrols, scanning machines. All of those things are part of resources necessary to effectively respond to TUC. Otherwise, they will have knowledge that they can't apply because they're not enabled to apply that knowledge. And that's the point I wanted to emphasize. On my last slide, I was also asked to highlight capacity building initiatives that are necessary. And I think I've spoken to development of training curricula, integrating those as mandatory trainings, targeted and practical trainings, but also awareness raising as a strategy for capacity. So this, what we're doing here, is one such example of many conversations that need to happen, and not just cross-country, but also inter-country, intra-country, intra-agency. There needs to be a lot of platforms where we are honestly exploring our limitations and our challenges and agreeing what we need to do. And platforms like EAP I mentioned, EAPCO, EAC exist to facilitate these kinds of interactions. So that's a big component of capacity. And then there's interagency information exchange platforms, judicial colloquia, and name it. All those platforms facilitate the ability to focus and to agree on what strategies we need to explore. Lastly, in terms of evaluating how effective we are, or how effective our policies and legal frameworks are in countering TUC, as well as monitoring our emerging trends and adapting, I haven't come across very specific adaptive mechanisms that we have employed here across countries to be able to evaluate how effective we are. What I do know, however, is the pressure of obligations arising from international conventions or regional commitments of countries have sort of forced countries into having some sort of action plans that they work towards. So you'll find, I mentioned the Tanzania Action Plan for Trafficking in Persons, for example, draws largely from its obligations of the UNTOC and the regional obligation at EAC level. And then that becomes sort of a tool they use to measure how well they're doing vis-a-vis the implementation of that action plan. But there isn't a lot of such similar action plans across the region, unfortunately. What I propose is we could look at an assessment of the legal frameworks we have vis-a-vis their alignment to international legal frameworks and regional frameworks as a way to evaluate their effectivity. We can look at the quality of jurisdiction emerging from court as a way to determine whether or not our judicial officers are in fact equipped to adjudicate TUC. We can also look at success rates for prosecuting agencies in terms of how many cases are successfully prosecuted, how many fall through, what are the challenges with those that fall through. That could also be a way we assess our success rate vis-a-vis the cases we prosecute. We can look at the functionality of the institutions that are mandated to deal with TOC cases as a way to assess, again, our effectiveness. Because it's also one thing to set up an institution because the law requires us to set it up. It's another for the institution to function. So that's another way we could assess our successes. And then lastly, of course, centralizing our data and ensuring that data is continuous can give us a clear picture of our success or the lack thereof, and also what we need to do based off of the data that we gather. And we do need to set accountability mechanisms for our institutions. I know that those ones that have a statutory mandate already have accountability inbuilt in majority of their guidelines, their regulations, but as members of EAC, and probably facilitated at the EAC level, we do need some level of accountability beyond the obligations that are created in law so that countries can speak honestly to their situation and also then highlight, like we're doing now, what our challenges are and what we can do about them. That will be the end of my presentation. I apologize that it was quite long, but I think I leave the remaining time for any questions or discussions. Thank you. Over to you, Brenda.
Thank you so much, Lorraine. Thank you so much for the presentation. It's okay, we've learned a lot. I think I can read some of the comments from the participants. John Koba says, it is good to have the information. And then at the border cities, we can get the citizens informed. There is need to have a framework to ensure public participation in our border cities, to ensure that public participation in our border cities is enhanced. He also says Busia has issues in the lake where fish folk suffer in the hands of military in Uganda, and to us human torture and then property taken and never returned. Dr. Edward Agoth says, thank you, Dr. Odero and Lorraine, for enlightening us with the presentation. I think now we can move on to the Q&A session. Kelvin Kamau asks if, do we have a central data hub for TOC in Kenya or regionally? And is there a statutory institution mandated to collect data on the same? So I don't know who between Lorraine and Dr. Marcella would want to answer that.
So I think we have the National Counterterrorism Center, which does it for Kenya. I'm not so sure if it's expanded to transnational and organized crime as such, but regionally, I'm not so sure if we have anything.
I echo Daktari's sentiments that that's what we have in Kenya. And yes, it's specific to terrorism. And actually the debate has been whether its mandate should be expanded to cover broad transnational organized crime issues. So as it is, we still rely on global platforms for information. Unfortunately, we rely on the Global Crime Index, for example. We rely on the UNODC reports that they generate, but we don't have in-country centralized data collection for TOC specifically. I haven't come across anything in the region. I do know that this is one of the recommendations that has been put forth by EAC member countries to look into, see if it can be facilitated at EAC level.
Thank you so much. We also have a question. I think it's from Edward Agoth, who says, what about the pastoralists when they cross borders within East Africa in terms of security, since we know most of them are not subject to fingerprints and screening? So how do we address this issue?
That one sounds like an issue, Daktari, you would know how to deal with.
The problem with there's a dynamic that, as the world is evolving, will not evolve anytime soon, and this is our African nature of extended relationships. By this I mean this: in every border you go to in this country, The Somalis in Kenya are related to the Somalis in Somalia. The Busia fisher folk in Busia are related to the Busia fisher folk in Busia. And while the world is evolving, there's a part of us which is our cultural, social cultural activities that will not evolve. But like I said before, we normally use drones, and at the borders now, there's the use of drones to monitor activities and passage. This is in the remote areas because we have realized that these are the places terrorists use a lot when they're coming in and out of the country. And thankfully, because you see, you cannot explain to a Somalia crossing from so you cannot explain to a Maasai, for example, moving from Serengeti, because when there's food on the Kenyan side, they will move to the Kenyan side. When there's food on the Tanzanian side, the Kenyans will move on the Tanzanian side. This is a challenge of our porous borders and the large landmass we have. It is something we try to deal with. But thankfully, for example, from the Kenyan and Tanzanian side, we have something called Kenya Police Reserve. And Kenya Police Reserve, most of them come from these communities, and they're able to help us identify the persons passing from one end to the other. It remains a large challenge, but you'll find that most of this, hopefully one day we'll get there, but this is something we need to, at the moment, it's a hard thing to deal with in terms of, because even that process of telling somebody that you want to take their fingerprint, there's a cultural aspect of maybe you want to kill them or you want to do this or that, and they will not even accept, and it might elicit a violent reaction from these kinds of people. So with the monitoring using advanced technology, we're able to tell that, of course, there's a possibility that it might be a terrorist or a criminal or a this and this, the concealment, but the KPRs are on these routes, and they're able to sometimes help different countries monitor the inwards and outwards without the normal migratory patterns. I hope this explains a bit the challenge and an answer to that. Thank you.
Thank you so much, Dr. You can make use of the Q&A toolbox. We have started the Q&A session. Raise your hand so that I can allow you to speak. I'll allow Caroline Kidaiga. You can unmute and ask your question. Caroline, can you hear me? Okay, we'll move to Michael Wiso. Michael?
Yes, how are you?
Yes, I'm fine. How are you?
Good afternoon. Yeah, my question is a bit, it's still on organized crime, but a bit away from terrorism and the rest. Mine is on market securities, capital markets business, where most of the worst crimes are committed online, and Kenyans have been victims by criminals online, enticing Kenyans or other business people with good returns and end up losing millions and millions of shillings. Yet to get these guys is also very difficult because they're not physically seen, except as they raise their emails and whatever immediately after calling people. How do we suggest the remedies on this? Are you getting what I'm saying?
Yes, yes.
Yes, I think I've finished my questions. Just a question where I'm looking for suggestions on how to combat, because it's one of the worst transborder or transnational crime, because the perpetrator is maybe in Dubai and the victim is in Kenya. How is the law? How can the law remedy this, please?
This is quite a big challenge. It's one of the most current or fastest emerging crime. And the problem with cyber crimes of this nature is that, like you've said, they're very fast and very swift, and sometimes finding these people is hard. But thankfully, or just as a counteractive measure in Kenya, for example, banks are now being capacity built in the sense that sending certain amounts of money is one, restricted, and there's proper you need a thorough explanation to do it, and two, through the Financial Reporting Center, which we have in Kenya now, because of this large illicit transfer of funds that move from one center to the other. We're trying to combat this, for example, by freezing. In Kenya, mainly, we have witnessed a lot of illicit flows incoming rather than outgoing. And we have a lot of situations where the Financial Reporting Center and the banks, once the banks raises an alarm that we suspect suspicious, we have very stringent suspicious activity reporting mechanisms. And when this is reported, the money remains frozen. However, the challenge comes here. Somebody sent 500,000, $1 million US, or let me say, the small amounts, again, even in Kenya, for example, or in the East African region, you receive this message for M-Pesa, this M-Pesa fraud, your money is stolen, right? And then you find that the people are locally within the country. The challenge, however, comes in the sense that we do not sometimes have a complainant, which is the biggest. The money might be there, the money might be frozen, but we do not know. It is sometimes difficult to send the money back or return the money when nobody has come forward and said that my money was stolen. But we try and freeze the funds and to freeze the accounts. There's a lot of restrictions when it comes to money transfers, and especially where banks realize that one might be a fraudulent transaction. The challenge, however, comes whereby, like you said, money has gone to Dubai. It becomes very difficult. But with Interpol and all this international cooperation, sometimes we try and get mutual legal assistance and request for the funds maybe to be returned back to the country, and they do the same. And this is how we work with most of this, where it's within East Africa, it's a bit easier. Outside East Africa, it becomes a big challenge because data protection, the layers and layers and layers of bureaucracy. However, you find that there's cooperation between countries. For example, Kenya and the UK, for example, because people have been capacity built to certain levels, is that we have mutual agreements whereby when we request for mutual legal assistance, the process is a bit faster because we have been trained on you need to present A, B, C, and D, and then that way we are able to retrieve the funds. But it remains the biggest challenge because Kenya goes through more than 5,000 or 10,000 cyber attacks in a day, according to the last report by the National Cybersecurity Center. And this is all in terms of fraud. So because it's fast moving and quite fast paced, and the technological know-how is also quite high, we try using the interagency cooperation institutions, we try restrict and try prevent it through restricting the flows of funds, because moving money outside the country, again, you require quite a lot of documentation to present, but it's a very big challenge that we try and counter, but it's not easy, I have to admit. Thank you.
Thank you for that. We have Charles Hamala. Let me kindly unmute and ask your question. Charles, if you can hear us, kindly ask your question. Okay, move on to Hakil Ngonja. He is asking whether, are there in place feasible arrangements within the EAC set up for harmonization of laws and regulations upon which to have smooth operations and common position when it comes to collaboration with personalities and preferably institutions outside the region community?
Okay, let me attempt at responding at Charles's question. Charles, yes, yes, there are efforts, ongoing efforts, both in terms of conversations on how harmonization of laws can be achieved. I did mention that as a bigger challenge for harmonization is actually at the center of that conversation is the balance between the sovereignty of a country and its right to have its own national laws tailor-made to its context vis-a-vis the regional agenda, which encourages collaboration. So it's a difficult one, that one. On one hand, countries are very apprehensive around the idea of harmonizing legal frameworks because of that. But on the other hand, the same countries appreciate that there's a need to have sort of a streamlined way of approaching legal issues. I speak especially in the context of TOC. And so what EAC has done to a great extent is explore the use of protocols and strategies and regulations for its member states as ways to harmonize practices. So much so that even though countries have their national laws, they are members of EAC, so therefore they are committed somewhat to the guidelines and regulations developed at EAC level. And I did mention earlier in my presentation, I gave examples of some of those that have been put in place at EAC. But I hear your challenge that in terms of ability to prosecute TOC cases, the issue still remains countries have their national laws and the limitations thereof and jurisdictional limitations about this. And that I unfortunately don't have a straight answer for, but it's an ongoing conversation, I know. And EAC is trying to convince its member states to break boundaries there. The same way we've done with travel and with trade and investment. Those barriers broken there to enable EAC countries interact with each other more is the proposal made for national legal frameworks as well. But we wait to see how that builds. I hope that's useful information, Chance.
Thank you for that. That was Hakil Mugonja who asked that question. Charles, I don't know, you are changing your device. I don't know if you're able to hear us now.
Hello, I can hear you quite well. I don't know whether you can hear me.
Yes, now we can. Proceed with your question.
Okay. This is now my mobile phone. Thanks. Well, what I wanted to contribute is this, because I've heard a very elaborate rendition of international instruments, and the worry, it was mentioned that political will is problematic because that's where the rain starts beating us. I just wanted to illustrate it with a current situation which we're having and maybe suggest a way forward. The situation that we are observing is the one we're all familiar with of our good friend Felician Kabuga, who it is alleged imported machetes through Kenya. 1 million people, 500,000 machetes were imported, 1 million people died within 3 months in Rwanda. So there's a transnational element. I know it's an international crime, but with the genocide that happened in Rwanda, the observation is this. Well, it's no secret that Kabuga spent a lot of time in Kenya and he was never renditioned. He was never extradited. He was never taken to the authorities. But more recently, the Kabuga case has ended because he's unfit to face trial. So he's mentally, I think, dementia or something. The thing is, that theory of whether or not he imported machetes through Kenya had to be dropped by the prosecution because they found it hard to prove. To make a long story short, and that smacked of lack of cooperation at a very high level. So there was not only non-cooperation in arresting a fugitive, there's also non-cooperation in facilitating the prosecution hypothesis. So I felt that despite the plethora of instruments, the fact that most corrupt people necessarily are those people in power. The reason that we are not seeing any reduction in corruption, for example, is largely because the same instruments require those people to facilitate their own prosecution. So there has to be some other entity, maybe civil society, maybe some other entity has to be empowered to have a voice in implementing these anti-corruption measures. And finally, even at the level of prosecution, we don't yet have a regional court. I know there was the Malabo Protocol, which contemplated whether we're going to prosecute corruption and other transnational crimes. But the fact that it has never, come into existence, it demonstrates the lethargy and whether there is really, consensus among us as individuals, as countries, about the seriousness of these problems that we're speaking about. Yesterday there was somebody, a billionaire, who was convicted. A 67-year-old lady was convicted for stealing about $44 billion in Vietnam over the past 11 years, and she's got the death penalty. We never hear those kind of things happening in our context around here. But thanks for the detailed rendition of what I felt was rather positivist, because it does capture the provisions of law, but there needs to be some evaluation of the extent to which these provisions are translated into action by way of implementation, and evaluation of the efficacy, whether it's going to be to increase the capacity or something, but somewhere in the middle of it, we have not yet owned the fight against corruption and the fight against transnational crime in many ways. Thanks a lot for the presentations anyway. That is all from me. I don't know whether, yes, I can see Madam Ochiel.
Thank you, Charles. You didn't ask a question, so I will not respond, but I only want to agree with you that the challenges you've highlighted are exactly as you've highlighted them. I agree with you that we must move away from the setup of legal frameworks, operational frameworks, and institutions in itself as a standalone solution to these issues. Because it's one thing to set them up, it's another to ensure they're working. And so the conversation has fairly moved. There's a lot of ongoing conversation around what are the real implementation challenges of the frameworks we have, because we continuously highlight how much legislation we have and how good they are and how facilitating they are. But that challenge you raise remains. Without that political will, they are just legislation. They're just paper. But one of the things I've seen explored quite a bit in the region, I mentioned at the beginning, I hope that IDLO's work in this area currently focuses in Kenya, Tanzania, and Mozambique. And one of the things we've tried to do is to bring the implementing agencies to the table for these discussions. Not so much the high-level policy-making representatives, but the specific implementers, because they are the ones who know where the challenge of implementation is. And an example I'll give is we are trying to convene, for example, the competent authorities of mutual legal assistance in the 3 countries to just put them together to have a conversation on why aren't the agreements you have working? And with these challenges that you've identified, from where you sit as a technical people, what needs to happen for these agreements to work? So for me, those honest kinds of conversations and the creation of those platforms that are not populated, by high-level decision makers are a way to facilitate dialogue that would help us collaborate. Because unfortunately or fortunately, collaboration is a voluntary process. Countries cannot be compelled to collaborate. And so that goodwill becomes a thing we cannot overlook. In my view, it's just us finding or exploiting ways to bring us to the will that we need, but also to really get into the challenges experienced and what solutions are proposed for those challenges and following through those challenges. I know some countries have tried to set up independent bodies, for example, to create checks and balances against corruption, for example. In the case of Kenya, the advent of the EACC, for example, was just that you want a body that's independent and a body created by statute, but independent enough to be able to provide the checks and balances against, including government officials and high-ranking government officials when they are the perpetrators of the offenses we are talking about. But again, that has its own challenges that we cannot explore now. I agree with you that we need broader conversations around this and strategies. Yeah, thank you.
Thank you for that. Maybe you can take the last question. This is from Niyukuri Francois, who is asking, considering the atrocities in the DRC, can we say that the clashes between the Congolese army and the M23 constitute organized crime?
Daktari, do you want to have a go at this one? I don't feel equipped to respond.
I'll try and respond because these are crimes of military in nature. There's something called command responsibility and individual criminal responsibility. If you look at the history of the International Criminal Court, it was set up because of such situations. And that is why we cannot say organized crime, because organized crime is for a profit purpose. And these are offenses. I want to be very careful with my answers on this. This, I would say, are criminal offenses that are of, I don't want to use the word war, but because they have a military content, they have a military type of nature in them. I would say there might be crimes against humanity or war crimes or something of the sort. And they would not fall really under organized crime because when you look critically at them, they do not have a profit element in the real sense or in a critical sense. I think this is how I would answer it, and I would say there would really be crimes that would be charged under the international criminal, under the ICC statute rather than under organized crime or transnational organized crime and things like that, because they have a military element towards them. So it would be individual criminal responsibility of the persons. And if you look at individual criminal responsibilities, they are mainly set up to charge those who are higher in command rather than the individuals who are doing what? Following the rules that have been set for them. So it's not really organized crime, but international criminal humanitarian law is where they would fall on. Thank you. I hope that answers you.
Thank you for that, Daktari. John Koba says this is a very fruitful meeting. It will be good for the team to liaise with the Strong Cities Network, for they have good materials and networks that will be grateful to be part of the meeting in Arusha for the discussions next month. I will communicate the same to the committee. I believe we have come to the end of our webinar today. I would like to thank our panelists for their time, expertise, their knowledge and dedication, which has truly enriched our discussion. Their valuable insights into the complexities of cross-border crime and your innovative approaches to tackling these challenges have provided us with invaluable guidance. Also, wish to express our sincere appreciation to everyone who has joined this webinar and for your thought-provoking questions. I want to encourage all of us to continue this dialogue, share insights, share with our friends, and explore opportunities for collaborations. And once again, I will be welcoming you next month for our webinar, which we will share. We usually share in our email. By our, I mean East Africa Law Society. Thank you so much and enjoy the rest of your weekend. The webinar is over, so we can leave at your own pleasure.
Thank you. Have a good weekend.
Thank you as well, and have a lovely weekend.